So welcome to this session of the YCC conference. The session is Comparative International Law, and we are going to have 6 presentations dealing with several different aspects of the interplay between international law, comparative law, international jurisdiction, and so on and so forth. I will start. I am Antonia Baraggia. I am an associate professor of comparative law at the University of Milan, Italy. And now I am one of the 2 co-chair of the YCC. I'm really pleased to have you all here. And I would like to immediately start with our first speaker, who is Thomas Verhellen, Assistant Professor of European Union and International Law at Utrecht University. Thomas is going to speak about the separation of trade powers in the EU and in the US, the case of unilateral instruments. Please, the floor is yours. We cannot hear you. You have to unmute.
The classic mistake. Thank you very much. I will try to, I think I have about 10 to 15 minutes. I'll certainly stick to that time frame. The paper I wrote, as Professor Baraggia announced, is entitled The Separation of Trade Powers in the US and the EU, the Case of Unilateral Instruments. I'll first say a few words on a bit the context and the wider project within the context of which I've been working on this paper. Then I'll kind of introduce the paper, the premise, the approach. Then I'll say a few words about the findings, and then I'll end with some next steps. So first, the context. As I mentioned, I'm talking to you from Ann Arbor in Michigan. So this academic year, I'm working on a research project in which I try to kind of map and comparatively explore accountability mechanisms in the context of trade policy in the United States and in the European Union. The premise of the project, a bit the backdrop, is what I kind of perceive as a change in the international environment. This is well documented. Multilateralism is under pressure. We have geopolitical change, rise of China, relative decline of the United States. The European Union kind of trying to chart its own course between those 2 superpowers. Also, and this is maybe a development that's a little bit older, increasingly trade policy is being used by states and regional organizations such as the European Union in pursuit of policy objectives that are unrelated to trade. So we can think of social fairness, environmental justice. And in this changing geopolitical environment, we have also witnessed an increasing pursuit of security objectives. And that's a little bit what I focus on. As trade instruments are increasingly used for security and other policy objectives, and as international legal disciplines become less strong, international dispute settlement becomes less effective, trade becomes more political, more geopolitical. The stakes rise when we talk about trade in that type of context, which leads me to emphasize and explore the role of domestic governance, the role of domestic accountability mechanisms in the specific context of trade policy. So that's a bit the background. And the aim of the project is to, as I mentioned, map the different types of accountability mechanisms that exist on both sides of the Atlantic, compare, identify false necessities, and maybe think about possible avenues of reform, both in the European Union, which is my own area of expertise, but perhaps also in the United States. So this is really I would like this to be a 2-way street. So the paper that I've been working on zooms in on one aspect of this discussion: unilateral trade instruments. Unilateralism is something we have, which is very much coupled to the developments that I mentioned earlier. We have seen both in the EU and the US an awful lot of legislative developments in this area, new instruments that have been introduced, and existing instruments that have been kind of beefed up or updated, reformed. Think of trade remedies or investment screening in both the US and the EU. So in this paper, I look at 8 such instruments, which, by the way, I define in a very broad way. I define unilateral trade instruments as unilateral instruments that affect economic and financial relations. So that captures both traditional trade instruments, import restrictions, but also maybe less obvious instruments, financial sanctions, both of individuals and on countries, but also restrictions on data flows. So a really broad definition, unilateral trade instruments. I look at 8 instruments, 4 in each jurisdiction, the EU and the US. For the US, I look at IEEPA sanctions, so sanctions the president can impose in the presence of a national emergency. I look at Section 232 sanctions, measures that can be imposed in the presence or whenever that is deemed in the interest of national security in the United States. Section 301 measures, when trade practices by third countries are considered to harm US commercial interests. And also Section 311 of the Patriot Act, which are financial sanctions. So banks, financial institutions, or countries that can be excluded from the US financial system when they are deemed a threat or a threat to the integrity of the US financial system. But we have seen that these measures have also been used as foreign policy instruments, which makes them very interesting to look at as well. And then in the EU context, I look at the enforcement regulation, which is a regulation that allows the Commission, European Commission, to take retaliatory measures when third countries violate trade rules. And very recently, these rules have been changed to allow the Commission to do this even in the absence of a binding WTO appellate report. So that's a big shift, which gives the Commission more discretion. Hence the importance of these accountability mechanisms. I look at the blocking statute, which allows the Commission, which really acts as the executive in this area of exclusive EU competence, which allows the Commission to compel companies and persons not to comply with extraterritorial sanctions. I look at the equivalent of those financial sanctions that I mentioned in the US context, where we have in the EU an anti-money laundering directive that again allows the Commission to add countries or financial institutions to a list which of countries and banks that are deemed harmful to the EU financial system, which then entails an increase in due diligence requirements. And in the near future, there is talk of beefing this up further to really get to some kind of equivalent to the US system of financial sanctions. And then finally, restrictive measures, which are kind of the key instrument in EU foreign policy. So these 8 instruments, I look at very straightforward questions. Who decides? So who can adopt these measures? And what are the accountability mechanisms that apply to the decision makers and that kind of constrain, or it's supposed to constrain the decision makers? I distinguish there between substantive checks and procedural checks. So substantive checks are the substantive legal conditions attached to or that need to be met before a power can be exercised. So often there's a delegation of powers, so there are conditions attached to that delegation. It's kind of, it goes back to the previous panel that I was listening into on delegation and legislative oversight in India and the UK and the US. Procedural accountability mechanisms or checks are power sharing arrangements. So you have the decision maker and the power to decide is shared to a lesser or greater extent with another institution. So that's a bit the setup. Moving to the findings. I have some straightforward findings and then some findings that, to me at least, were more intriguing and that lead to new questions that I hope to look into further in the months ahead. Straightforward findings are, there is often delegation involved. So constitutionally, the power to adopt these measures lies with the legislature. That's the case in the United States and also in the EU. whereby in the EU, the legislature consists of the Council, consisting of the member states, and the European Parliament, representing the citizens of the EU. Very often there's a delegation of powers, but not always, and that's the first observation. When it comes to restrictive measures in the EU, so the ability for the EU to freeze assets of individuals, Russian individuals related to the Crimea crisis, for example, that is legislative power exercised by the Council alone. The Council cannot delegate this power to, for example, the Commission. Really the opposite of what we see in the US, where this is a presidential power and the president alone gets to decide. Also, the level, that's the second more straightforward point, the level of detail of the substantive checks I refer to really differs both between instruments and also between the two jurisdictions. In the US, there is really a tendency to formulate broad substantive conditions when it is required by US national security, or when there is a national emergency, which is for the president to decide that such an emergency exists. In the EU, broadly speaking, although not across the board, the substantive conditions are more detailed. So those are more the straightforward ones. The more interesting ones, there are 4 of them. First one, well, 2 of them relate to the EU, 2 of them relate to the US. I'll start with one that relates to the EU. The role of the European Parliament when it comes to legislative oversight is comparatively weak. And there is really no constitutional explanation, I find, for this weak role. You have different ways of delegation of power in the EU, and I can't go fully into detail, but you have delegated acts, implementing acts. The European Parliament plays a role when it comes to delegated acts, where it can oppose individual measures proposed by the Commission. It does not have an equivalent role in the context of implementing acts. That's an aberration, I find, in a system which is essentially a bicameral system. The European Parliament is often involved in delegating the power. It is not involved in exercising oversight. Very different from the US, where always both houses have a role to play. Second point has to do with the US. In the context of legislative oversight, where you have in 1983, the Supreme Court, in the case of INS versus Chada, ruled that it is unconstitutional for one house of Congress to have the ability to terminate measures adopted by the president. IEEPA sanctions are a good example of this. And this was very common prior to this ruling. After this ruling, you need a joint resolution. So both houses of Congress need to adopt a joint resolution, which the president must sign. Now, this is a way for Congress to exercise oversight over the president. So the president needs to sign off. You need a 2/3 majority to override. So question mark, how effective is this system? And it's interesting to see that commentators have different opinions on whether this mechanism still has a role to play, 1, and 2, if it does not, whether there are alternative mechanisms that are efficient. And if there aren't, what alternative mechanism we could maybe envisage. And in the paper, I tried to formulate a proposal there that kind of looks at the EU. So that's a second point. The legislative veto, as it's called. What is its status? What is its effectiveness today? Should it be reformed? Third point, I mentioned that restrictive measures in the EU, that they cannot be delegated to the Commission. In addition to this, the Council adopts such measures by unanimity. Again, mirror image of the US, where you have a single actor that gets to decide on the adoption of restrictive measures. Question mark whether such an arrangement is appropriate in a context in which it is often important to act quickly, and a context in which it is important to also act in the collective interest. When you need to act by unanimity, every member state is a veto player. This is a long-standing discussion in the European Union, and it is interesting, I think, to reflect on what are the pros and cons of unanimity, and if we consider that unanimity is no longer an appropriate arrangement, then what is the alternative, and what accountability mechanism should we then introduce? So that's a third point and question. And the fourth and final point that I found really interesting in this comparative analysis is the role of judicial review, where you have, and really in the past couple of years, this is a discussion that has become quite prominent in the United States with the Trump administration, acting rather vigorously, let's say, taking unorthodox measures, which then led to challenges before the federal courts, challenges aimed directly at presidential orders. So not through agency action, but directly against the president. And it was interesting to observe how US courts struggle because there is a large tradition of deference towards the executive in the US, which coupled with these open-ended substantive checks that I referred to before really leads to an arrangement in which you can ask yourself, are there any meaningful checks? Interesting comparison once again with the EU, where the executive is much less powerful, more substantive checks, more procedural checks also, but also more stringent judicial review. And there are debates on whether it should be even more stringent or how stringent it exactly is, because the Court of Justice isn't always consistent. But what is clear is that the Court of Justice will look at the facts behind decisions taken by the executive. It will verify whether the reasoning makes any sense. It will look beyond the four corners of a decision taken, whereas in the US, if the presidential order, if the standard of review is one of what is called rational basis review, courts are really very differential. And there again, you can put some question mark on whether that is a good arrangement or whether something more akin to what exists in general administrative law in the US is appropriate, where courts can review for arbitrary and capricious action. So these are a bit the four comparative reflections that came out of this analysis. This is the first paper, so I'm wrapping up. So in the next couple of months, I'd like to zoom in further on these questions. I'd also like to look at recent developments in treaty making practices. So this is about unilateral instruments, but also in this new geopolitical environment, there have been changes in how the EU and the US make trade agreements. We can think of Brexit, we can think of the deals that the Trump administration has been making. So that's something to look at. And also to kind of connect this analysis with legislative developments that are coming up. And in the EU, we're going to have a proposal in the next couple of months for an anti-coercion instrument that would allow the Commission to take measures against states that try to coerce the EU or its member states. What does that mean? It looks like something that will grant the Commission a lot of discretion, which will make these accountability mechanisms even more important. I'll end there.
Thank you so much, Thomas, for this really interesting comparison about the two systems. I have already some questions, but I will keep for, as I promised, for the Q&A session. So let's move on with Al-Mohammadi Bander, who is SJD candidate at the Kansas University Law School. And he's going to present his paper on the SPS agreement and climate change. Please, the floor is yours.
Thank you so much, Antonia. I think that would be a good transition from Thomas to me because we talk in the same area. First of all, thank you so much for having me. I'm so thrilled to be here in front of scholars from all over the world. So basically, my paper would be, like you said, the SPS agreement and climate change. I'm trying to connect the dots between them. I'll share my slides here. So let me just share screen. Give me a second. Okay, let's go to start. Play from the start. Sorry, let's go back. Can you see my screen? Okay, thank you. So I'm trying to begin. Okay, let's go. Okay, I'm trying to use the slides, and then I put some of the context of my paper in the slides in case we have disconnection. Sometimes the audio, I have some issue with the audio here. So in this paper, I would like to address the issue of how climate change affects the income inequality of countries in terms of putting restrictions on animals affected by climate change, animals and plants. So consequently, the developed countries generate more wealth, and developing countries struggle with the disaster of climate change effects. So what is the motivation of this paper? When the COVID-19 hit, I looked to some of practice that countries have been doing since the pandemic hit. And then due to the spread of coronavirus, does the WTO restrict imports from certain countries based on the WHO recommendation to protect the national health of states? And do countries apply SPS agreements that make their decisions justifiable and reasonable to prohibit specific animals products? I will highlight the cases that has been indicated by the trade practitioner and conclude that how disaster comes from animals affected by climate change leads to income inequality between developed and developed countries. And first of all, I want to address sanitary. SPS stands for Sanitary and Phytosanitary Measures Agreement, that known as SPS agreement. And then I will shed light on the implication of climate change on the SPS agreement that impacts the agricultural commodities, including plants and animals. I would shed light on development of the SPS agreement. The SPS, one of the key roles, one of the key roles in the Uruguay round trade negotiations between nations in the world, the SPS measures that are based on legitimate health concerns. Many SPS measures exist with more questionable basis. So the climate change and the SPS agreement, as you all know, human activities play a huge role in causing the warming of climate change, in which leads to cause a massive danger to food security and the globe. The most vulnerable countries are affected by climate change and its impact are the developing countries, because they don't have reliable infrastructure as well as the capacity that could resolve the impact of climate change in terms of agricultural commodities. However, one of the agreements that could or might help the countries to encounter the impact of the climate change at the SPS measures. In recent years, globalization of agricultural trade has attracted attention. International trade in agricultural products may become a way to develop and spread pests, diseases, and environmental health hazards to areas that are no longer obvious. And countries usually need to restrict the import of agricultural products through the development of SPS measures to ensure that they are free from such danger. And countries may propose unreasonable SPS measures to protect their manufacturers and the food industry to compete. The SPS agreement requires that the measure depends on logic, standards, and scientific measures. The measures should be encouraged to be a framework for international standards. It should be like a harmonization for the country or for the countries around the globe. The SPS agreement, the SPS measures explicitly recognize the scientific and technical competence of the three international standard setting organizations to do so. The first, the World Organization for Animal Health, OIE, the International Plant Protection Convention, IPPC, and the third one, Codex Alimentarius Commission Codex for Food and Safety Issues. And there are many goals for establishing the SPS agreement. and that to encourage them to make SPS agreement harmonized around the globe. One of the important goals is that all countries shall adapt the international standards based on standards basis to avoid any discrimination or unjustified reason that could lead to an arbitrary application of the standard. So hence, nations will not compete between them to flourish the global economy as well as the domestic economy. So all the above organizations are linked to the WTO. All the organizations, or all the international that I mentioned now linked to the WTO. The WTO defines the SPS measures as follows: to protect to protect animal or plant life or health within the territory of the member from risk arising from additive contaminants and dioxide or disease causing organisms in food, beverage, or feed stuffs, to protect human life, health within the territory of the member from risk arising from diseases carried by animals, plants, or products thereof, or from the entry, establishment, or spread of pests, or to prevent or limit other damage within the territory of the member from the entry, establishment, spread of the pests. Sanitary or phytosanitary measures include other relevant laws, regulations, requirements, procedures, including end product criteria, processes, and production methods, testing, inspection, certification, and approval procedures, quarantine treatment, including relevant requirement associated with the transport of animals or plants, or within the materials necessary for the survival during transport, provisions on relevant statistical methods, sampling procedures, and method of risk assessment, and packaging and labeling requirements directly related to food safety. And moreover, Article 2 of the agreement highlights clearly that all members should make SPS measurements without any unjustifiable or arbitrary discrimination between members. Now, I turn to, to the climate change and impacts on the agricultural commodities. According to the report that's prepared by the State of Agricultural Commodity Markets, SOCO, SOCO 2019, that presents for the Food and Agricultural Organizations of the United Nations the range of 0.5 Celsius to 103 Celsius caused by the greenhouse gas emission between 1951 until 2010, as shown below in this. As shown below on this map, as you can see, how the climate change around the globe impacts our Earth. And you can see here the summary of the projected changes in the crop yields due to climate change over the 21st century. As you can see, the chart here, the increase in yield, that decrease in yield in this chart. So now I'd like just to go and talk about the impacts of climate change on plants. So there's correlation between all the species who live on the Earth and climate change. By default, any change in the climate will affect all species, including human, animals, and plant products, more importantly concerning agricultural products. So the issue here, the impacts on the plants, as you know, we all heavily rely on plants and their products. We need to pay more attention to the health of the plants, and that provide the necessities of life. One of the factors that affect plant health is pests. The IPPC defines the pest: any species, strain, biotype of plant, animal of, pathogenic agent, injuries to plants or plant products. The climate impacts plants and their pests both directly and by implication. Changes in temperatures, water accessibility, carbon dioxide, outrageous climate occasions, precipitation, and ozone levels to influence plants and pests, and may prompt organic association, which wouldn't occur under stable conditions. Now we turn to the impact of climate on the animals. Animals around the globe, rely significantly on the plants. Any change or damage to plants due to climate change will automatically affect animals and their products. The primary source of animal food is plants, as directly affect the animal life. There are factors need to be considered when we look at the impact of climate change on animals. The factors are effects on physiology, effects on distributions, and adoption. Based on the WHO recommendations regarding any animal production from any country around the globe, countries should take into consideration all the above factors that I just mentioned now when they make their decision concerning import and export the animals production from any specific country. The reasons for prohibiting any animal products from any country or region must be reasonable, scientific. Otherwise, it will be unreasonable and discriminatory. Consequently, developed countries will reap the benefit of banning the import of animal products affected by climate change by increasing their income. On the other hand, developing countries, as I mentioned earlier, will struggle with their income. For a decade, there are many disputes arise between nations regarding the application of the SPS agreement and prohibiting food and agriculture between nations. Most of the application of the SPS are capricious and arbitrary. For example, in 1998, there is a case of discriminatory treatment between European countries and certain African countries. The European Communities, EC, imposed a blockade on imports of fish from some African countries. Since that, they have resumed trade on the grounds that WHO provided evidence that the fish wasn't a problem. In this case, we find there was no issue to ban animal products from certain African countries. The EC, the European Communities, did not provide legitimate and reasonable reasons that support their decision, or measures that the EC needs to be taken into their account must be on the risk assessment. Moreover, the SPS agreement emphasizes the principle of the transparency and equivalence. Due to the lack of measurements of risk assessment, as well as the lack of transparency and equivalence in our case, the restrictions were lifted by the WTO. So now I highlight some cases that show the application of the SPS agreement between countries kind of capricious and arbitrary. We don't have transparency. And then the SPS measures need to be reformed and to be more efficient, more than it is now. So the first case, Japan apples case. I don't know how much time do I have, Antonia, so I don't want to take more time.
Yes, 2 minutes.
Oh, okay. Try to make it so fast. Okay, the Japan apple case, apples raised by the United States on March 1st, 2009, concerning the restrictions that Japan imposed the imports of apples from the United States. The United States claimed that Japan violated Articles 2.2, 2.3, 5, etc. Japan failed in this situation, failed to provide the scientific evidence to justify their measures. So under Article 2.2, the appellate body found no evidence. So the Japan violated the SPS agreement. Also in Article 5.1, the same thing. There was no evidence, so the Japan failed to provide any evidence to justify their action. The same thing with the Article 5.6. The same thing with the Australian salmon case with Canada. Australian government imposed some restriction on the salmon case from Canada based on the scientific justification, but the same thing, Australian government did not provide the evidence that proved their decision. So therefore, they failed to justify their action based on the SPS agreement. Trying to make a story because the time. The last case I want to mention here, EU beef case. This is a long case between EU and United States. European Union banned hormone beef from the United States. The panel found that the European ban on the meat treated with the chemical hormone from the United States was inconsistent with Article 3.1, 5.1, and 5.5 of the SPS agreement. Trying to go to the end, we don't have time here. So the appellate body reversed the panel's finding that the European measure through arbitrary and unjustifiable distinction resulting in discrimination or disguised restriction of international trade in violation of Article 5.5. So as you can see from these cases, still there's an issue with the SPS application. Most of the time, the application are being applied in arbitrary method. There was no transparency. There's no specific or a clear answer about the application of the SPS between countries. So I would like just to conclude from the cases above, the SPS agreement needs to be a monolithic standard. Otherwise, the SPS will continue to be disputed. As a result of the SPS application, developed countries, like I said, like I mentioned earlier, they're going to increase their income. So we have to put into our consideration the climate change, how the climate change affects the plants and animals, and then we try to incorporate the climate change impacts on animals and plants into the consideration and put it in the SPS application when we apply the SPS measures between countries. Finally, just want to show you this kind of charts, the impact of international food prices. As you can see, the prices of rice and wheat, maize, and soybeans it is not stabilized, and you can see the increase and decrease of the price of this kind of products. The same thing, climate change plus economic impacts on the rice production. As you can see, South Asia and East Asia and Pacific and European and Central Asia, you can see the huge difference between them in terms of price of products. The same thing here in maize production. Okay, the conclusion here, just as I mentioned, we need to reform the SPS agreement and incorporate the climate change impact into the SPS agreement. Thank you so much for listening to me. I'm so sorry for taking time.
Don't worry, Bander. It was needed all the time you take, because it is a very interesting and complex topic. So I hope to have time for questions as well. Thank you so much, Bander. And now I would like to introduce our next speaker, Edward Becher Torres, a PhD candidate at McGill University, right? And he is going to present a paper titled Redeeming Individual Remedies in Social Rights Litigation, International Standards, Rights Formalism, and the Complexity of the Local. Please, the floor is yours.
Hi everyone. It's wonderful to be with you today, even if unfortunately it has to be remotely. So a bit of a change of tack for my presentation, moving into the realm of comparative constitutional law. I'm a scholar interested in comparative social rights, so constitutionalized rights to healthcare, housing, social security, education, that kind of thing. And what interests me specifically is the questions that are posed on the remedial end. So once a court has already decided that there's been a deprivation of rights, what can then be done practically to help realize complex public goods like healthcare and housing? So today's presentation is on a particularly vexing topic within this field, and it's the place and desirability of what's called the individual remedy. So let me just share my screen. Hopefully hopefully we can all see that. So giving individual remedies in social rights litigation their due. So what is an individual remedy? Well, it's a court order at the end of litigation that tries to fulfill a social right, healthcare, housing, education, but only for the litigants before the court. So in contrast to what are often called complex or structural orders that attempt to address a structural or systemic human rights deprivation, here the court's intervention is much more modest. It's really just concerned with fixing the problem for the litigants before it. So my central question is, how can this kind of relief be appropriately designed? Because what becomes clear is that these individual remedies are in fact highly controversial, even amongst otherwise supportive social rights scholars. And they're controversial for several reasons, but most pressingly, because they can actually result in outcomes that are anti-poor or regressive. So not totally intuitive, but the general idea is that wealthy individuals in countries like Brazil, in countries like Costa Rica, in countries like Colombia, have actually succeeded in persuading courts to award them things like expensive medicines that are experimental, or expensive medical treatments that are low on the priority list, but that suck resources away from public programs that would have otherwise benefited a broader public, including the poor. So that's really the concern, is that this kind of remedy, on a kind of viewed from 30,000 feet, these remedies collectively can actually divert public resources towards low priority needs for the rich and away from general social programs that benefit the poor. The paper that I'm sort of in the process of writing is trying to rehabilitate the individual remedy, at least in a narrower form. My hunch is that we shouldn't abandon this kind of relief so quickly. For one, it's proven to be, despite its risks, one of the most available and effective vehicles for vital relief for poor individuals. So we can take a look, for instance, at practice in Colombia, where there are thousands of claims that are filed in healthcare litigation every year, many of which are from poor individuals. These claims are usually successful. Sometimes they provide vital relief. And the state actually complies with the orders in over 75% of cases, or at least studies seem to have suggested that. So that's actually, this is viewed from a more positive light. This is the stuff that human rights lawyers dream of. When we compare the situation to more ambitious structural orders, like declarations or institutional injunctions, we find that these are much rarer. They involve a much heavier investment of judicial resources. And they're also beset with a number of compliance issues. Oftentimes states refusing to comply or taking years and years and years to do so. So all that to say, I think there's a space for this kind of remedy, and that we should do what we can to kind of rehabilitate it and create a sort of fruitful space for it where these rights are recognized. And this is also, it might be worth adding, where international law gets involved. Because in a lot of the countries where we see this anti-poor or regressive outcomes are cases where courts have actually drawn on international standards in their rights jurisprudence. So we find, for instance, courts in Brazil, courts in Colombia, courts in Costa Rica, referring, for instance, to the International Convention on Economic, Social, and Cultural Rights. We find them occasionally referring to general comments that actually outline in very specific detail what these rights include, like the right to healthcare. There's a list of what the core of this right includes. And it's often by relying on these international texts without perhaps adapting them to local circumstances, without being sensitive to context, that actually results in regressive anti-poor outcomes. So I think one of the sort of top of line suggestions that emerges from this research is that courts would sort of be better off listening to international norms a little bit less in their jurisprudence and focusing a little bit more on how they can craft orders that are sensitive to a local political context. Okay, so let's talk a little bit about outcomes. So in the course of my research, I've narrowed in on what I take to be 3 different spaces where individual orders can actually do a lot of good. So I think with the balance of the time I have, I'm just going to kind of quickly canvas what I take these to be. So the first was what I call confronting administrative dysfunction. So what does this mean? Well, it means court orders can compel the delivery of goods and services that have actually been promised by public policy, but which state actors have actually failed to deliver. And this happens surprisingly often. It's actually a major it's a major feature of Colombian healthcare litigation, where you have private insurers that are meant to be making disbursements so that individuals can pay for included medications, but which are refusing to do so, often because they exist in an environment of very weak regulatory oversight. So if you actually look under the hood of the thousands of cases that are filed in Colombia for healthcare rights every year, there's actually a surprising number, somewhere between 65 and 75%, that are for included benefits, things that policy is meant to guarantee, but which, because of, I guess, administrative dysfunction, hasn't been delivered. And in these cases, as you can imagine, the court actually provides a reliable vehicle for relief. Individual orders here support rather than subvert the existing distributive scheme and can make important strides towards fulfilling human rights. Okay, second, individual engagement remedies. So these are orders that direct government actors to engage meaningfully and respectfully with rights claimants. So they have been popularized in South African evictions law. Basically, there have been a number of cases where the cities have moved to evict sometimes hundreds of individuals from a site. And the Constitutional Court of South Africa has given the green light to these interventions, a green light to these evictions, but has insisted that before the eviction takes place, the city must meaningfully negotiate with the affected population. And it's outlined a procedure to do so. So these have actually inspired a lot of very promising rights outcomes. Oftentimes it gets the city down at the table with the affected population and civil society organizations, producing kind of creative solutions that improve the situation of the vulnerable. There are also soft remedies in the sense that courts aren't dictating substantive outcomes. They're not outlining rights and enforcing them in a hard way. Instead, they're creating an administrative procedure that is more rights conscious. And at the same time, they encourage political actors to invest in their own rights respecting capacities so that hopefully political actors going forward will internalize this kind of way of doing things, even when there isn't litigation that's on the table. I think that this is justified for all those reasons and more. I also think that this avoids the kind of anti-poor or regressive outcomes that I outlined earlier. Oftentimes what you see as a matter of practice is that these kinds of creative rights respecting solutions don't take away from non-litigants or other poor individuals. Instead, it creates new spaces where rights can be fulfilled without harming those other groups. It manages, for instance, in the housing case, to, just to cite one example, the court was met with a case where there was an eviction of about 400 individuals from a site where commercial developments were going to go up. The remedy in this case encouraged the municipality to negotiate for an on-site upgrade for the community. So this meant that there were about 400 individuals who are now no longer on the public housing waiting list because they had something durable. That benefits, if anything, the people who are not currently before the court, because it removes people from the queue without taking away a spot that was already there. Okay. Last, and perhaps most controversially, I've called sort of vital relief that's sensitive to context. So the sort of key question of the paper is, okay, so you have cases where there's administrative dysfunction where the courts can help, but should courts press further? And that's truly the difficult question. Just going through this quickly, because I know I'm running out of time. I've suggested courts should proceed with individual remedies in these cases, but subject to certain disciplines. So first, relief should be limited to cases where it is truly vital, which means that either lives are at stake or the outcomes would be catastrophic. It also means that where relief is sought for things like medicines, there should be compelling evidence suggesting that these medicines are effective and safe. It also should mean that individuals should be required to prove that they can't pay for the good that's sought, because courts in Brazil and Colombia haven't always required this. Courts should also be confident that what is claimed could be universalized and the order will not unduly prejudice non-litigants. So again, for instance, one of the issues with current practice is that in places like Brazil and Colombia, the courts will provide 24 hours for the state to comply, which leaves the state with very little time, and they're often paying for goods out of the budget that's earmarked for other things. Providing slightly more time might be one practical way of getting that money sourced from other places that don't necessarily harm the poor in the end. And the last thing is courts should facilitate access to justice. There's a lot of things that courts can do in-house to improve the situation. So deformalize proceedings, relax the rules on standing, but admittedly, some of this stuff requires legislative reform. I think the corollary is that if a court happens to be in a jurisdiction where there isn't access to justice and where this is sort of widely established, then perhaps it should avoid issuing individual remedies altogether, because in that case, it really will be only the rich that can access this form of relief. So those are the sort of three pillars that I've earmarked. But again, this is a sort of ongoing project, and I'm certainly looking forward to seeing how it evolves. Thank you.
So thank you so much. So I don't know if there are questions from the audience. Yeah, anyone who wants to pose a question? Because I have some questions, but I don't want to abuse my role as chair. So okay, Athena, please.
Thank you. I have the slides.
Sorry, I'll.
Sorry. Okay. Now, thank you. I have some questions on the last topic. You said that South African courts, in their restrictive tendencies, do not explicitly condemn the state to take actions, but slightly showing that the evictions problem and other decisions about the water and the deprivation of water the government in South Africa had imposed in some very poor parts in Soweto, few water supply every day, because there was not water at that period for all parts of the population. Only the rich population could have more. Some parts of the population introduced actions, and the court said that they cannot do that, they cannot intervene so directly. And they will not harm other non-litigants. I find exactly as you said that in that case nobody's harmed. If one poor litigant wins the case, that creates a precedent, and after that, other poor litigants, they have the similar problem. They are privileged, they can bring their cases and be sure that they will win because of the precedent. So nobody is really harmed from the population that is really affected by a governmental measure. To my judgment, it should be more combination of the international standards, and many courts, national courts all over the world, have not recognized. What have you done as a legal scholar, and what actions are planned or now running in your research area to combine the Covenant of International Covenant on Economic and Social Rights to the jurisdiction of national courts, and if the courts are not willing to follow the lines of the Commission of the Covenant, what actions can be done after to bring cases at the international level? Thank you.
Thank you. It's a difficult series of questions. I'm inclined to agree with you on your first comment about how oftentimes we underestimate how valuable individual litigation can be for people down the line. I know there's a tendency in social rights scholarship to say that any kind of litigation that's undertaken by the rich is for that reason a bit suspicious. But my sense is that, well, there are certainly lots of cases where poor individuals or NGOs have been able to piggyback off of precedents and litigation that's already been undertaken by more well-resourced litigants. So we don't necessarily have to have the sort of instinctive hesitancy about, or categorical hesitancy about litigation that's undertaken by well-resourced individuals. In terms of the question about combining approaches, it's interesting and difficult. I think there are constitutional norms that are going to be in place in each of these jurisdictions that's going to set the terms of the relationship a little bit. So in South Africa, as you must know, there is an injunction in the constitution for courts to consider international law, but not to impose it as an outcome in disputes involving the interpretation of the constitution. So that opens up a nice space where South African courts can consider general comments and stuff like that, but where there's a healthy space where they can distance their jurisprudence from international approaches, which is what they've done. In other places, sort of in American jurisdictions, there's much more of a relationship of direct application. And I think that's, you know, as for the reasons I mentioned, that can also be a bit dangerous because you might end up applying legal materials that were designed in a very different context and for very different purposes. The general comments are not meant to be judgments in discrete cases, and they're largely distant from the particulars of the local jurisdiction. So yeah, but to your question about whether there's approaches that try and combine the two, I'm not sure. Yeah, my instinct is yes. I mean, everyone starts off from the assumption that there should be at least some relationship between domestic constitutional norms and similar international norms that are being elaborated on the international plane, but a kind of sophisticated and nuanced way of sort of balancing local and international perspectives is beyond me. And I'm not sure I've read anything that's sort of very elaborately or sophisticated that sets out that relationship in a very persuasive way.
Thank you. I see that both Bander and Thomas has.
Yeah, I just quick question here, Ada. It's interesting. I like your topic. So you mentioned that the court should facilitate access to justice. Do you think if we put kind of obligations on the court to facilitate access to justice would exhaust the court? Instead, the government should facilitate access to justice instead of the court, because the court will just be dealing with litigation instead of facilitate access to justice.
So let's also keep the question by Thomas, so then you can reply if it is addressed to Edward. Yeah, okay. Yeah.
It's a very short question. Which jurisdictions are you looking at, and how did you select them?
Okay, Thomas's question is a bit easier, so I'll answer that first. I started looking at India, Colombia, and South Africa, so 3 very usual suspects for social rights research. In the field of individual remedies, it's a bit difficult because there's very little or there's relatively less that's being done in India, which has a preference for more kind of complicated structural remedies. And there's also a bit less done in South Africa. So my focus has shifted instead to Latin America, where there's not only lots of practice, but also a rich body of local scholarship in places coming from Brazil and Costa Rica, in addition to Colombia. So this particular research sort of, I would say, spans those 5, but really focuses on Brazil, Colombia, and Costa Rica, and for reasons relating to, again, the rich body of local scholarship and judicial practice. On Bander's question on access to justice, I agree. It shouldn't and can't really be only the court that pursues this kind of work, in part because oftentimes these are going to relate to laws of civil procedure that are going to be enacted at a legislative level anyway, and sometimes even at a constitutional level. So it certainly has to be the government's job not only to create a kind of comprehensive scheme for access to justice, but also to sort of, where there are lots of cases that are proceeding before courts, governments should be more responsive to that and address the underlying systemic issue so that it relieves pressure on courts from having to act as a kind of safety valve. So I think that's certainly, that's the primary duty there, is to be sensitive to what's going on in courts and perhaps use courts as a way of sounding out where the structural issues are.
Well, thank you so much. We are a little bit running out of time, but I would like to ask a question, one to Thomas and one to Vander. So the first one to Thomas is because your comparison is really convincing. So the framework of your analysis, it's really convincing. But so I was wondering whether you can explain the differences between the US and the European Union with the inherent different nature of the two legal orders. So we are in the EU, it's not in a federal system. So even the European Parliament is weak and so on and so forth. So even the Court of Justice, in a sense, maybe more cautious in stepping in and so on and so forth. So I was wondering whether you justify or you can find a justification of this difference in this inherent nature. And I was also interested in the last point that you raised, because I didn't get very much about the coercion, the point of the new regulation about coercion, but so maybe I will write to you to learn more, because I'm interested in coercion on a different point of view. So I'm studying conditionality, so I will have a private chat with you on this.
Okay, yeah, I'll respond now. Oh.
Yeah, okay. Then I will go with Vander. Yeah.
First, I look forward to your message on the coercion instrument. About the inherent nature, maybe the first thing I'll say is that in the context of trade policy, the EU does have exclusive competences. So if there is any area of lawmaking in the EU where the comparison is a bit, let's say, more straightforward with the US, then it's probably trade policy, which is one of the reasons perhaps that I also zoom in on this area. That of course doesn't apply to the common foreign and security policy. So these restrictive measures, they are outside of the scope of the EU's exclusive competences. Second point is that the inherent difference, I'm always very careful with these essentialisms, like the US is a state and the EU is just, well, everyone has a different name for it, I guess. Is it a federation of states? Is it a quasi-federal system? Is it just an international organization? I kind of shy away from those, and I look at, in that sense, my approach is very, very legal. I look at what are the legal rules and what is the institutional practice that comes with it. There are big differences, and I think the main is in the US, the founders have established a strong presidency. In the EU, that's much less the case. So these differences are there, but they in themselves I find very interesting, because they create these mirror images where you have strong presidency, weak review. In the EU, weak executive, strong judicial review, and then that creates a space to think about why and should it be this way, what can we reform, and so forth. So that makes these US-EU comparisons, despite the obvious differences, I find very stimulating. Hope that answers your question.
Yes. So it's a different approach from a constitutional lawyer that look at the sense of the legal order. And
where's the sovereignty?
Yeah.
Well, the essence of federalism, if I may, is that sovereignty is divided, and that is the case both in the US, where you have a lot of state opposition. If you just have to look at what's happening in Texas, where you could argue that the supremacy of federal law is collapsing before our eyes. And you have that in the EU with, if you just look at Poland.
Exactly. On these we can agree, okay. So thank you. And a last question to Bander. So in the end, so you highlight that the SPS application is still too arbitrary, okay? So I was wondering whether in this arbitrariness plays a role the precautionary principle. So so how sometimes restriction can be justified under this principle of the precautionary principle. So if you do not have enough evidence, or if you do not consider that the evidence are enough, the scientific evidence are enough, you can apply this. And of course, this may open the field for an arbitrary decisions. I don't know. So how is the role of the precautionary principle in the SPS agreement decisions?
Yeah, I mean, the issue is the precautionary now, especially nowadays with COVID, a lot of restrictions now put on export and imports of production between countries. The issue is still we don't have elements that we could apply in order to justify the action if you put some restrictions on the products. Basically, the international trade needs to find a way to apply any elements that could be in common between countries, and all the countries agree on it, and then apply it on any production that we import or export. Otherwise, still, we're gonna go have many disputes arising from now until indefinite time. We don't know. Still, we have disputes arising from the application because the ambiguous application of the SPS. As a precaution, yeah, some people would go with it because that would support domestic products instead of having international products from outside the territory of the country. So protectionists would like this idea because that means we're going to support our national products, and then we could increase our income. However, still, I don't know, I'm trying to find out this kind of piece of paper of my dissertation, try to find out the common standard that all the international community could agree on, and find common sense between countries on the application. Otherwise, we're gonna go continue the arbitration and arbitrary application of the SPS agreement.
Thank you so much. So now we have to move on with our three last speakers. So I'm pleased to introduce the fourth speaker, Patrick Mercedes. She is a graduate student at the University of Milan in the Master of Sustainable Development. And she's going to present a paper on sustainable futures and intergenerational justice. Please, Patrick, the floor is yours.
Thank you very much. I'm just going to turn my camera for 10 seconds just to say hi and introduce myself. I hope you can see me. Yes, I'm sorry, it's a little bit dark. Hi, everyone. Yes, I will start to present my paper on sustainable futures and intergenerational justice. I'm going to share my screen so you can see this brief PowerPoint that I prepared. Just 1 second, please let me know if you can see it. Can you see it? Yes, okay. Okay. I will divide this paper basically into two sets. One will be recapping a little bit what is sustainable development. I will try to be brief, and a little bit of its history and where are we standing now in terms of sustainable development, in order to have a clear idea on what we can establish a sustainable future and the development with intergenerational and intergenerational justice. Just to create the link and to follow the ideas. So yes, in this regard, to understand this dynamic of sustainable futures and intergenerational justice, like I was saying, it is it is important to understand sustainable development. And in a nutshell, and I will try to be quite brief about it, we can recall that during the post-war period and the colonization processes, economic development was at the center of the recovery efforts. However, with the rapid industrialization, especially of developed countries, and of the problems of poverty affecting mainly developing countries, it leads to a fast human-induced environmental degradation. This situation, what it did was to generate the need to reconcile the concept of development, which was in the very beginning understood as simply economic development, integrated with the environment and with the society. And in this process of reconciliation, especially with the environment, new processes, new approaches to development were developed. And in consequences, the roots of sustainable development, how we know it today, emerge from this development and strengthenings on the principles of international law, especially in the decades of 1970s and 1980s. This is basically the decades when it blossomed, if we can say it like that. So in a certain manner, it's quite easily to understand why many times when we read, for example, about sustainable development or sustainability, we see that the concept is quite integrated to the environmental part rather than the economic or social part. So it is important also to recap and to keep in mind that in those decades, so 1970s, 1980s, with this development, is when environmental matters found a place in the international community. So the scientifics started to spread the voice and to spread the issues that were all over the place regarding, for example, climate change and deterioration of the environment, biodiversity loss, etc., etc. Very quickly, let me present this part. So by 1972, the United Nations carried out its first conference on the environment, which was in Stockholm. And this conference represented the first major environmental gathering focusing on human activities which were relating to the environment. And I would like to bring attention to the fact that this conference brought attention to the preservation of the environment, but recognizing that it was essential to economic development along with social process. I mean, basically what it did was to bring together the idea of reconciling environment, society, and economic development. And that's why I wanted to present you this part of the of paragraph 6, which stands as to defend and improve the human environment for present and future generations. It became an imperative goal for mankind and a goal to pursue together with and in harmony with the establishment of fundamental goals of peace and of worldwide economic and social development. So moving forward with this same declaration, there are 3 important points that I found out while I was reading it and analyzing it. The first point was regarding the oversimplicity of the concept of sustainable development, which I explained before, which was referring mainly to environmental concerns. And there was a need brought by the international community to broaden it and to reconcile it with the society and with the economic development. The second point is the call for developing and developing countries to come together and to face the problem that were arising. So it happened because for what we have studied about the development of international environmental law, both developing and developed countries made a contribution to this development, but they did it from different perspectives, taking into account, like I was explaining in the beginning, that developed countries had a focus on matters of industrialization, for example, while developing countries were focusing more on eradication of poverty and this type of situation. So, okay. Let me just move this a little bit. So later on, from all that I have said, these ideas were synthesized basically in the 1987 report of the World Commission on Environment and Development, commonly known as the Brundtland Report, which synthesized this idea into the nowadays known definition of sustainable development, which refers to the development that meets the needs of the present without compromising the ability of future generations to meet their own needs. I don't intend to tell the whole trajectory of sustainable development because we don't have that time and I didn't prepare for all of that, so I'm going to move to this part. What I'm presenting here quite briefly is like this line of soft law and hard law instruments that have served as a base to construct what is sustainable development today in terms of rules and in terms of practice. So I just want to mention briefly that sorry, here, this part. Okay. I just want to mention quite briefly that despite the literature addressing sustainable development has continually grown, let's say that the biggest call for integration has been since the launch of the Millennium Development Goals and especially of the Sustainable Development Goals. Here we can have the biggest boom regarding sustainable development. But now that we have talked about all of these international agreements, conventions, instruments, regional, where do we stand today in reality? In terms of law, we have a beautiful international community with a beautiful commitment. We have Agenda 2030. We have 70 development goals that are still going on, still not achieved. But in terms of reality, we are standing where? We are standing in a new epoch that is harming the present generation and of course the future generation and the distribution of the rights of the resources and of everything. And I try to be quite brief in this part in order to follow to sustainable futures, which is the most interesting part, I would say. So very briefly, the Anthropocene is a new epoch, which is basically the main characteristic is the human influence as the main agent of change on the planet, which has been shifting the world into what was kind of a stable into a more unstable in terms, especially of environmental matters like climate change, but not only that, of course, also in social and economic terms, because we have very clear that the impacts of environmental issues are not only environmental matters, but they translate also into economic and social matters. Okay, let me just continue here in order to be brief. So what is sustainable futures? And while I was preparing this paper, and I read a lot of papers about sustainable futures, I myself brought these questions. What does sustainable futures mean? Because this could be, or this is a quite broad concept. Well, it depends, I would say, and from what I have investigated, where we see it. On the one hand, we could take, for example, the perspective of the definition itself of sustainable development. And then we could say that, for example, sustainable future is the ability of the future generations to meet their own needs. See, it sounds quite simple if we see it from this perspective. But then on the other hand, which is, I would say, a little bit more complicated, we could think about sustainable future, understanding that it can mean something different depending on the region, on the country, on the person. Okay, I'm sorry. I will try to be brief. I'm so sorry. And okay, and in this same regard, then I had another question: which are the needs of the future generation? We do know which are the needs of the present generation, but do we know what are the needs of the future generation, and how are we going to do something in order for them to meet their own needs? Because something that is real is that the world in which we are living now, and the society in which we are living now, the laws that we have now, the situations that we have now are not the same that will be probably in 20 years, 40 years, 100 years. And I think that one of the partners was presenting before this graphic with the situation of climate change and the SPS, and which was quite interesting. So although we don't know which are those needs, there is something that we do know. We both, present generation and future generation, need an habitable planet. We need both generations need a planet where to live, biodiversity, with access, a strong human rights foundation, equality, a strong political arena, and so on. And that is the reason why justice takes an important role in the discourse of sustainable development, or sustainable future, sorry. This is because generational justice affects the distribution of resources and the life opportunities between generations and within generations. And in this sense, it's imperative that the decision and resources dedicated to the present and the future sustainable development be based on the respect and equality of both contexts, present and future generations. So I will try to close with this part, because I know I still have a lot to say, but the time is not enough. And I will try to conclude with this. The means to guarantee a future, sustainable future, and I will say also, of course, a sustainable present, if we have to say it like this, and the achievement of both intergenerational and intergenerational justice, I bring you the definition in here, is through the protection and the fulfillment of human rights, and on the national ground and at the international level as well. So at the national level, we can be done under the requirements of constitutions, and at the international level, having a strong binding instrument. I am really sorry. I was just finishing here because I guess I don't have more time. I will keep that as my conclusion. Thank you very much for your attention. And I'm really sorry for taking this much time.
No, don't worry. These are all very complex topics, so don't worry, but my role is also to keep the time, and I'm quite flexible, so
yes. Before maybe if anybody has questions, I just would like to say thank you for this time in here. It's been amazing hearing you all, and also to share this time with you. And I really can hope that maybe in a future opportunity I can share you something that I would like to do with this topic, but within the region of the Caribbean, my region. So I hope in another moment we can share this, this investigation. Thank you very much.
Sure. So thank you so much, Patrick. And now we move on the next speaker, Dorota Czerwinska. I'm sorry if I didn't pronounce correctly your surname. You are research assistant in criminal proceedings department at University of Wrocław, and you are going to present a paper on protecting the defendant's right in negotiated justice mechanism, a comparative perspective between efficiency and fairness of proceedings. Please, the floor is yours.
Thank you very much. I'm really glad to be here. A little bit sad not to be in Wisconsin, but nice to meet you this way. I would like to, well, just to like finish the introduction, apart from, because what you said was obviously true, but apart from being a research assistant, I'm also a barrister specializing in criminal law. That's why my perspective on the defendant's rights in negotiated justice mechanisms is a little bit poisoned by some practical experiences. As part of my doctoral thesis, which is also the theme of a research project I run, and I'm legally obliged to disclose this information. So I'm doing this because the project is financed by the National Center of Science in Poland. I'm conducting comparative research on plea bargaining type institutions, because obviously in countries, in European countries, those are negotiated justice mechanisms that are not plea bargaining themselves, but they're obviously inspired by plea bargaining mechanisms. In order to propose an optimum model, but an optimum model obviously not for the whole world, which is impossible in the field of criminal procedure, but an optimum model for Polish legal system. And such model should establish an optimum equilibrium between the efficiency of proceedings, finding the truth, achieving a just result in a fair way, as well as protecting the victim's interests. But today I will focus only on one of the aspects, namely procedural safeguards that should be introduced in every system of negotiated justice in criminal proceedings, in order to protect the defendant from the risk of making a misinformed or even coerced decision. Because one of the most serious allegations that is raised in the legal scholarship of almost every country against plea bargaining and other negotiated justice mechanisms are the allegations connected with plea bargaining being one of the causes for convicting innocent defendants and exerting undue pressure over them in order to enter a bargain. The countries I chose for my research are as follows. It's the USA, it's the mother country of plea bargaining, so that's obvious. You can study plea bargaining without taking into account USA. Then I have France. Today, like the explanation is dualistic. There is a pragmatic reason I speak French, but there's also like French system is very protective over the defendant and is very well balanced in terms of achieving just results and at the same time taking into account interests of various participants. So it's a very interesting one in this topic. Then I chose Germany, which is also a very interesting country for studying negotiated justice mechanisms, because they were developed informally, even like hidden from public opinion and the legislator, and were only afterwards regulated by the law. And the system is characterized by a particularly active role of the court. And then I have Italy. Italy is obviously a very important field of comparative research in criminal procedure, because it's a system that is kind of at a crossroads between adversarial and inquisitorial one. And of course, Poland is my mother country, which in terms of the aspect I will be discussing, I am actually discussing today, is very unprotective over the defendant in comparison with the other countries. I will try to be as brief but as informative as possible. When assessing the level of protection of the defendant in negotiated justice mechanisms, the first factor you have to take into account is the presence of the defense counsel. In USA, of course, the plea bargaining is the predominant method of resolving criminal cases, and in general, in every criminal proceedings, according to the US Supreme Court standards, it is mandatory to provide the accused with a defense counsel appointed by the court in all cases which end in the imposition of a term of imprisonment, unless the accused consciously renounces that right. But in practice, the defense counsel usually is present, and what is more, the Supreme Court, with regard to plea bargaining procedure, underlines that the participants of the defense counsel has, well, it cannot only be formal, but it has to be effective. And in terms of plea bargaining, the Supreme Court stated on many occasions, but most importantly in a landmark case, Strickland versus Washington, that when you assess whether the assistance of the defense counsel was effective while entering a bargain, you need to take into account whether the legal counsel's actions were above or below an objective standard of reasonableness, and if the second step is to assess whether there is reasonable probability that had the counsel's action were rational, the results of proceedings could have been different. There has to be a reasonable probability that the results could have been different, and then you may quash a judgment that was based on a plea bargain and a plea of guilty, obviously. So on the surface, it looks like the defense counsel participants is effective and is guaranteed in the US. But however, the system of legal assistance is often criticized in American scholarship due to the fact that every professional actor of the plea bargaining scene in America, in US, has their own interest in quick closure of the case. And that unfortunately includes the defense counsel, who often is a court-appointed counsel, which could in fact lead to a situation where it is the interest of the professional participants of the procedure in quick closure that is taken into account above the interests of the defendant. Another important question you need to ask yourself when assessing the level of protection of the defendant is what happens to the defendant if the agreement fails, because obviously he or she has already pled guilty. So in the American system, obviously it is possible to change a plea. It is guaranteed by the federal rules of criminal procedure. The court has to advise the defendant of this possibility, of the consequences of changing the plea, of the possibility that a judgment that will be issued would be more severe than the previously agreed. So all the necessary information is given, and the change of plea is effective and by that I mean that well, it initiates trial, and the trial goes as if the plea of guilty was never actually entered. So the future defense is not jeopardized. But the biggest problem with protecting the defendant in plea bargaining, in American plea bargaining, are the unclear disclosure rules. Although obviously it has been said for many decades in the US that before trial, all the material exculpatory evidence has to be handed to the defense, it is still unclear in the Supreme Court case law whether this applies to pre-trial plea negotiation. That means that, especially in some states, the defendant may be forced to enter a bargain while not having access to material exculpatory evidence. So that makes the decision based on incomplete set of data, which like it's a threat to the fairness of proceeding. Taking my paper to Germany, the system in Germany is obviously completely different. Because in Germany, the main type of plea bargaining type institution is called Absprachen, and it is an agreement which is concluded by the prosecutor and the defense and the defendant and the court, who is an active participant to the agreement during trial. So the trial has already begun, and the parties decide to talk during trial. Defense counsel, there's no provision that formally guarantees the defense counsel has to take part in the talks, but empirical data as well as practitioners' experience show that defense counsel usually is present. It is rare. It happens rarely that the defense counsel, that the defendant enters an agreement by him or herself, although it is formally possible. Since the talks are happening during trial, the access to the case file is full because we are at trial already. So all the evidence is known by the defendant. But there is another serious risk. Formally in Germany, it is possible that the agreement is entered, so the defendant pled guilty, they agree as to the sentence, but the court continues to hear evidence. And only afterwards will issue the judgment. Between the moment of the approval of the agreement by the court and passing the judgment, there is a possibility of withdrawal, both by the defendant, obviously, but also as well by the prosecutor and the court, even if no new circumstances occurred. Because the provision is the wording of the provision only demands that some significant legal or factual circumstances that don't have to be new but may have been previously overlooked appear and indicate that the agreed sentence is no longer appropriate. So in theory, this is a serious risk because you enter an agreement and then the other parties can simply withdraw from the agreement. But there are two additional safeguards. First, the confession of guilt is inadmissible as evidence in further course of proceedings, but it stays in the case file, which is a drawback, obviously. But the second factor that minimizes the risk is the fact that in practice, almost always the agreement is immediately sealed with a conviction. So in practice, usually there is no time for anyone to withdraw, but that is a serious risk. The third country I would like to address is France, which is the most protective over the defendant's system from this I've been analyzing. The most typical institution resembling American plea bargaining in France is called la comparution sur reconnaissance préalable de culpabilité, or la plaide coupable, which literally means to plead guilty. The negotiations take place between the prosecutor and the defendant and his or her legal counsel. And what's the most important is that participants of the counsel in the negotiations is mandatory, even if the defendant, the suspect, because we are talking about the investigation, the suspect has not appointed a defense counsel previously, then he or she gets a court-appointed one because it is legally impossible to enter an agreement without a defense counsel. What is more, the defendant and the counsel have the full access to the case file, and upon their request, they have to be granted a 10-day period of reflection, and the offer remains valid for that period. The negotiations are fully recorded. A detailed minutes have to be produced. They have to include all important statements under the sanction of nullity of proceedings. So that should prevent the risk of luring the suspect into an agreement by false promises. And what is more, the agreement has to be obviously approved by the court, and the court has wide possibilities of rejecting the agreement. And in contrary to what we had in the USA, the courts actually do that. So sometimes they do reject the agreement, but the defendant is protected even if in such a case, because if the agreement fails for whatever reason, previous statements are inadmissible, but also they are removed from the case file. So the case file will not have any sign of previous talks and previous confession of guilt, which is very important for the defense in further course of proceeding. Italy, like I will shorten a little bit my well, obviously because we have Italians here, that's the most stressful part. So Italy is quite protective in general in criminal proceedings over the defendant, because we have mandatory participants of the defense counsel in criminal proceedings in general. So obviously in patteggiamento or applicazione della pena su richiesta delle parti, which is the mechanism comparable to plea bargaining. We have the full access to the case file because it has to be done at the no later than at the preliminary hearing. So it's after the closure of investigation, and the investigative dossier is available to the parties. And what is also an important safeguard in Italian criminal proceedings, including well, it also has impact on the assessment of protectiveness of the patteggiamento, is the inadmissibility of statements made in the absence of the counsel by the suspect towards the police. So that eliminates the risk, which is the most serious one in Poland, that the suspect gets some false promises, confesses the guilt, and those promises never like they don't turn into the reality. Because in Poland we have three types of agreements. I won't discuss them in detail, but what is striking is that in practice, most defendants in Poland do not have a defense counsel. There is a very small category of defendants who are deemed as unfit to represent themselves, and those are, of course, insane or blind or deaf. But the category is small, and in general, usually defense counsel is not present throughout the whole proceedings. And that includes entering a bargain, which usually happens at a police station with no defense counsel. And so the suspect enters the bargain by him or herself. And what is more, in investigation, both the suspect and the defense counsel they may have full access to the case file, but the access also may be restricted by the prosecutor. So there is a risk of making a decision with an incomplete knowledge of the evidence that is in possession of the authorities. The negotiations are not recorded in a detailed minutes, only the final arrangements are. And what is more, if the agreement fails for whatever reason, and the reasons are broad in Poland because they even include the right of the victim to oppose against an agreement, and that opposition of the victim binds the court. So even if the court sees the agreement as appropriate, if the victim opposes, the agreement fails. And all the previous statements are admissible as evidence and stay in the case file. So that seriously jeopardizes future defense. And so just to sum up briefly, crucial factors I've established, I decided to take into account are participants of the defense counsel, access to the evidence, no time pressure, formalization and recording of the negotiations so that the process is transparent, and admissibility or inadmissibility of previous statements in further proceedings if the agreement fails. France is the most protective country over the defendants, but Italy is almost as protective as France. The guarantees, what is particularly striking is that the guarantees do not seem to seriously jeopardize the benefits of the agreement. So we still get most of the cost saving and time saving if we protect the defendant a little bit more. Doubts are expressed in American scholarship with regard to disclosure, because it is claimed that at the stage of pre-trial negotiations, the prosecutor would have to dedicate too much time to assess what exculpatory evidence is material and has to be handed over. And also there are some doubts as to introducing the exclusionary rule towards the previous statement, because it obviously jeopardizes to some extent search for truth, which in Europe is the most important objective of criminal proceedings. But that's just a matter of answering the question: do we really need a confession of guilt as evidence, which has been stated in a particular purpose, and that purpose is no longer on the table. Thank you.
Thank you so much, Dorota. And now we are going to our last panelist. I apologize with Riccardo because it's very late. Probably I should have put Riccardo at the very beginning. I didn't didn't think about the time zone. So I'm pleased to introduce Riccardo Vecellio Segate, PhD researcher in international law at University of Macau, and he's going to present present the paper about resisting domestic courts, universal jurisdictions over international crimes, a comparative study of China and Italy. So please, Riccardo, the floor is yours.
All right, can you all see my slides?
Yes.
Okay. I will just, okay, fine. So hello everybody, and my my topic addresses the resisting domestic courts, the reason to domestic courts universal jurisdiction over international crime. This is a case study that compares China and Italy. It is part of a broader line of articles that have been publishing recently. The most recent is on cognitive bias and privacy rights and digital evidence in international criminal proceedings. And the main thread of this line of articles is the limits of current international justice through specialized international criminal tribunals. So by publishing this line of articles, I realized all the limitations of international criminal tribunals and I've explored possible alternatives to these limitations. Now, one of the solutions that have been proposed and practiced over the last few decades concerns the application of universal jurisdiction, which is a practice which has gained some traction also in Europe. You can say in Germany, for example, and in France. The introduction of universal jurisdiction in the course of criminal procedure. And indeed, I believe that universal jurisdiction is the future of international criminal law, but there are a few caveats, of course. One of them, and the most important probably, is the actual state participation into the EUJ project. So I still see patterns of resistance or even resizing, so much that there are scholars talking about an actual downward trend in other regions other than Europe, but also in Europe itself. Now, why did I choose China and Italy? Well, both have been already identified in literature as domestic UJ resistant, either because they are incompliant or because they are unwilling to uphold universal jurisdiction, but also they subscribe to alternative discourses on global justice. They have a strong regional appeal and geopolitical weight, of course, within their regions, particularly Italy. It's a regional and not global appeal. But they also share common civilizational roots, which go well beyond the Marco Polo, Matteo Ricci, and so forth story. Actually, the Civil Code of China, for example, is like draws significantly on Italian civil law. And this is relevant here because universal jurisdiction is not confined as a concept to criminal law. It actually started as a civil law concept. So, the links between these two jurisdictions are really strong also from a legal perspective. Now, in terms of political background and focusing on China, China is not a supportive, it's not very supportive of universal jurisdiction for a number of reasons. First of all, it wants to avoid vexatious litigation for political purposes. It wants to refrain from setting precedents, which could be later replicated against itself. It is also, it also supports criticism, its own criticism against other courts in other countries adopting universal jurisdiction. And it also contests NGOs' role in raising concerns and intruding, in the domestic affairs. You can just think about the recent problems in Xinjiang and so forth. Also, China's concerns with not destabilizing international relations. It is slightly annoyed at the West's sudden human rights awakening after it has developed through committing crimes and so forth. But also, China needs to be framed within a sort of South-to-South solidarity, third worldism in international law, and there is some room for claiming that it is also carving out its own exceptionalism by projection as the forthcoming superpower. So basically, they say, okay, the US doesn't support universal jurisdiction. We are the upcoming superpower. China is the upcoming superpower, so we shouldn't. We should follow the same path and try to be exceptional. Try not to concede too much to the international criminal law framework. But there are also more general legal reasons. So the respect for formal equality of states, the restatement of sovereignty also before international organizations, in the case of the ICC, of course, the principle, upholding the principle of non-interference in domestic affairs. The fact that adjudicatory jurisdiction for China can only be territorial, personal, or protective, so not universal. And that especially universal jurisdiction for China is not customarized in the absolute, but only in three forms, especially the obligation of audere aut iudicarim treaties, which they consider different from universal jurisdiction, broadly speaking. I forgot to mention one core point, that by universal jurisdiction, I mean both the application of international law by domestic courts and the extension of the ICC jurisdiction over citizens of non-parties. This is really core to the issue. Now, coherently with its stances, also on universal jurisdiction, China did not join their own statute, despite being one of the most, let's say, entrepreneurial states in the process towards the adoption of their own statute. It shared with India a number of concerns over the rule that I've just mentioned of the ICC extending jurisdiction over citizens of non-parties, which China considers to be in violation of the Pacta Tercis rule. And then there are also a number of other concerns. For example, it objects to the inclusion of war crimes in non-international armed conflicts, and it is also concerned about the prosecutorial motu proprio of the ICC prosecutor. Furthermore, it doesn't support violations of razione persona or razione materia immunity of foreign state officials, although there are a few exceptions to this, but I'm already running out of time, even if I've just started. And especially China claims that because the United Nations General Assembly 6th Committee has not reached any conclusion over universal jurisdiction, this is a sort of customary law by reverse. So basically they claim they haven't reached an agreement, so this is indicative of contrary opinion juris. So either there is no universal jurisdiction rule in international law, or it is desuetuding rather than consuetuding. So it is unbecoming international customary law. Okay, but there is also domestic reluctance to it. For example, if you take Article 9 of the Criminal Law of China, you see that universal jurisdiction can only be applied to crimes that are listed in treaties China has joined. And there are also, another number of reasons that you can see detailed here, and that I don't have the time to explain further. Now, let's take a look at crime-specific legal reasons. If you consider, for example, crimes against humanity, for China, they are necessarily related to armed conflicts and times related thereto. So yeah, and the problem, of course, here is to define what is an armed conflict, because this has rapidly changed over the last decades and years, particularly with asymmetric conflicts, hybrid warfare, and so forth. And here China has a lot to say. If you look at the policy papers, China explains what it means by armed conflict. But there is a very specific point which I actually draw from a beautiful, really wonderful article which was published by a colleague in the Leiden Journal of International Law. He basically made a crazy archival research and established that for China, armed conflict should address jus in bello and jus ad bellum comprehensively. So basically for China, what makes jus in bello lawful, what makes jus ad bellum lawful is how you actually conduct hostilities. So your behavior in jus in bello determines whether the jus ad bellum, whether waging war was lawful or not. There is no distinction between these two fields. And it is actually a very interesting point, which is not only Chinese. If you look at genocide, well, there are very blatant political reasons that I don't need to explain for the reasons why China is not really willing to uphold universal jurisdiction in genocide claims. But there are also other legal reasons. For example, the fact that for China, genocide is not is not jus cogens, differently from many other jurisdictions which consider it part of jus cogens. For China, only piracy is jus cogens, and indeed, if you look at the history of cases of piracy and universal jurisdiction, 2 out of 5 since the 18th century are Chinese. Yeah, and also for genocidal acts committed within the PRC, Chinese courts can, of course, address cases of genocides, but it will not be called a genocide applying universal jurisdiction. It will simply be called something else, applying domestic crimes as they are, encoded within the criminal law of China. When it comes to war crimes, China doesn't want to uphold universal jurisdiction because, again, it believes that international armed conflicts should fall within only international armed conflicts, so not non-international armed conflict, should fall within the ICC remit. And also because, in general, China believes that international customary law is being taken too far with progressive definitions, which are not, stretch really this legal regime too far. Interestingly, when it comes to the crime of aggression, now, first of all, China believes that it's only the United Nations Security Council which can declare the existence of a threat to peace. So waging war should be ordinarily considered lawful. Also because, as I said before, there is no real distinction between jus ad bellum and jus ad bellum and jus in bello for China. But before anything, the point is that the crime of aggression is by definition an act of state. So no individual is responsible for it alone, except formally for the head of state, who in turn in China should be automatically immune from jurisdiction, also exposed. So not only the Chinese leader, but also all leaders. Turning to Italy, Italy has a seemingly very different set of reasons for not upholding universal jurisdiction. Here again, we have a very enthusiastic supporter of the ICC, at least at the initial stages. Differently from China, of course, Italy is a party to the Rome Statute. And it's also a very highly rhetorical support, like-mindedness, public international law, humanization, and so forth. So Italy advocated for a number of views at the UN on universal jurisdiction, which again you can find here. I don't have the possibility to explain. The general stance in Italy is we support universal jurisdiction, but only under substantial Italian law. So we are not going to apply international crimes as they are phrased internationally. We are going to use the concept, but only applying our own criminal law, which is exactly the problem. Because if you look at the parte generale, the general part and the special crime-specific part of the Codice Penale, so the criminal code, you find several discrepancies between the Italian code and the international one. For example, the missing intent to destroy a group when it comes to genocide, or when it comes to crimes against humanity, you miss the extensive systematic attack against civilian population. Or when it comes to war crimes, you see only military as agents for crime, and pillage is only addressed when it is war related. So you see there are a lot of shortcomings. Okay, and also Italy did not ratify the 2010 Kampala amendments regarding the crime of aggression. Okay, I'm trying to conclude. And there are also other general non-crime specific differentiations between the Italian code and the international framework. Beyond this, there are also procedural deficiencies. For example, the bicameralismo perfetto, which means that laws in Italy are extremely complex to pass. There have been several commissions of study, Conforti, Kessler, Pianetta, Cariplo. They never ended up in laws, okay? Even though they mostly tried to say, yes, we should actually, conform our internal code to the international stances. And if you look at Europe, Belgium, the UK, Spain, you see some sort of downwarding trend as well. In Belgium, with the law that I mentioned, in the UK, you even needed the consensus by the Director of Public Prosecution of England and Wales. So you see a very, very huge downwarding trend. Okay, so these are the conclusions. So despite China and Italy being extremely different, of course, in many senses, human rights discourses, the geopolitical orientation, the fact that Italy upholds dualism in international law and China monism, okay? One, of course, is democracy, another is an autocracy. But beyond this, commonalities shouldn't be dismissed either. And my paper, which I'm going to publish soon, indeed tries to focus on the commonalities, okay? Both countries don't uphold a pure form of universal jurisdiction domestically, but only qualified forms thereof. Both countries have courts which are technically unprepared, okay, that feel quite wary of applying international law because they don't have the tools to do that. They don't have even the knowledge and the experience to do so. Both countries are concerned with obsolete war crimes, even if they express it in different terms. And both of them share a sort of very deep concern with the jurisdictional competition when it comes to advanced universal jurisdiction claims, because of course, when you have a universal jurisdiction claim, every country can claim, they have a universal jurisdiction over the same claim, which means that many countries will try to compete, politically to get the case if universal jurisdiction is cared about. Okay, so of course, this is a concern for both countries. Okay, I will stop here. So the link of the previous article is shared, and if you're interested in this one, maybe I can share it in a few weeks. Thank you very much.
Thank you so much, Riccardo. And I don't know if there are questions to our three sets of speakers. So I see that Bander raised his hand. So please, Bander.
Yeah, I have a question to Dorota. When you talk about the Defense Council in the United States, I don't know if you mentioned the presence of the attorney should be in the process of plea bargaining. The other issue that comes here sometimes here in the United States, the court all the time would like to make sure there was no coercion from the attorney when the attorney tried to convince the client to enter into a plea bargaining, because they don't want the client comes back again and then go with the insufficient representation that sometimes happen here in the United States, because the attorney did not represent the client in a proper way. So I don't know if you mentioned the coercion during your research or not. Dorota?
I hear the question. I'm not very sure I understood it properly.
So during the plea bargain, so the attorney is supposed to present the client. The attorney doesn't have to convince the client to enter into plea bargaining. So when they go to the court, the first question, when they enter into a plea bargain with the prosecutor in the case, the first question comes from the court to the client, directly to the client. Did the attorney enforce you, or did the attorney try to convince you to enter into a plea bargaining with the prosecutor, or you did your decision, or you made a decision based on your evaluation? You evaluate pros and cons of the case, and then you did your decision without any interference from outside. That's what I meant by coercion.
Okay, of course, obviously the responsibility to assert the voluntariness and willingness and consciousness of entering a bargain and waiving the procedural rights falls upon the court as well in all the jurisdictions. Actually, there are no systems that make the Defense Council the only responsible for that. So obviously the court is obliged to incline that matter, and from as far as I know, it actually does. The problem that is, because obviously my knowledge of American system is based on the knowledge of literature and some empirical research, of course, as well, is that since 97% of the cases are dealt in through plea bargaining and are dealt on the basis of a guilty plea, and it's like it's the default method of resolving the criminal case. And the trial tax is considered by most scholars as high and as really existing, because there have been some unclear empirical data whether the trial tax actually exists or not, or maybe it's a myth that in the same cases, comparable cases, the trial tax is actually paid by the defendants in the sentences they get. I personally do think that since all the actors on the scene think of it as a default method of resolving the case, I'm not perfectly sure whether every defendant is actually able to consciously answer the question whether the decision was fully his or her own. I'm not sure whether they're able to address the issue.
Oh yeah. You answered the question very good. So I had an internship here, or prosecutor office and public defender here all the time. When the client came to the decision to enter into plea bargaining, the first question the judge asked the client: did you make the decision voluntarily? Did you have any influence to make this decision, or your decision by yourself? So this, because the court doesn't want the client to come back again and appeal the decision if they don't like the outcome of the decision based on the insufficient representation in criminal justice in the United States. But thanks, yeah. One more question, Antonia, can I ask? Or?
Oh, yes, so let's do this. I will collect your question and Athena question, and then Edward, do you have a question too? A short one? No, okay, you right? Okay, so let's go with Vander and Athena first.
Go ahead, Athena, go ahead.
Thank you. So I have a question first for the environment, the environmental topic. The problem is, as the lecturer said, which are the needs of the future generation, how we can find a measurement to which needs to adapt our treaties. This is the problem. Maybe a first attempt would be that the future generations have in this concept, under the concept of environmental justice, the same need to live in the same or a better, even better qualitative environment. This could be a measurement. Although the technologies change, future generations, children have the same right to live in an environment of the same quality, not in a downgraded environment, downgraded pollution standards, air, nature, animals. Should we stand here at that point and say the future generations have a right to have the same environment qualitatively, or even a better one, not a downgraded one? Could we measure the future under these present conditions of the environment? This is first question. Second question is, how can we done? Every environmental international instrument, even the Paris Agreement by many, is a soft law. Many people and organizations, NGOs, take actions before the courts. In Germany, we have now an action based on Paris Agreement against BMW and Mercedes, and in that action is a right based on that Paris Agreement that these companies should be forbidden after a period of years. Should be forbidden to them to construct any cars they are not used completely clean energy. It's required that they leave completely the fuel energy. And these two actions are now in the court based on Paris agreements. Should we do something so active even with instruments they are discussed as soft law? Should we use every international instrument, everything we have, take actions? NGOs should take steps to achieve this sustainable development. I mean, every industrial great country has a problem, has industries, and the main problem is that these industries have many workers, and the problem that comes politically is, yes, my children have a right to an environment. I should not take the environmental quality away from my children, but I need money to feed my children. If I don't have the money because I don't have a job to feed my children will not access the future and the environment. So it's more an action that has to encircle the governments and make it clear that omitting jobs is not a solution. Creating another jobs is the solution. Making clean jobs, helping industries to make the changes that are needed, making changes in education, re-education of the workers, and not coming to completely sending people homes, because this is detrimental, economically detrimental. So this is for me the problem. Helping the economy going on and thinking of the future and the qualitative environment. The problem is now, what is firstly these needs of how we come to define the needs of the future generations, and what can we done to help the sustainable environment. This is one question. The second question is a long one. I don't know, close it, criminal, it's not, okay, it's enough.
If you want to do it, but you have to be very quickly.
Criminal, okay, the criminal topic, to the plea bargaining. I mean, I love the book you are writing, Dorota, and the comparisons, the 6 comparisons were perfect. I am more older. I would suggest you combine this French legal tradition with the roots, the deep roots, that the Napoleonic era starts after the absolute monarchy and the revolution. Before, in the absolutely monarchy, it was only a lettre de cachet, a signed letter of the princeps of the hegemon of the king, and someone could be arrested and interrogated without any defendant. After that comes the revolution. We have all these rights. The whole palette of the defendant's rights comes at that era. And then we have the American Revolution, and then the common law in England. We have first the Blackstone saying it's better to be freed 10 people that are capable than one innocent be brought to prison. And then we come to the founders of the American Revolution, inspired by the French Revolution and by the common law, Blackstone, Solar. Comes then the Benjamin Franklin and says better 100 to leave 100 capable persons than to bring in prison one innocent. That problem of the plea bargaining is very good. We have the Miranda rights. The problem that in some legal orders, as in your Poland, the Polish legal order, someone can be interrogated without having the Miranda rights. This was a main historical turn in the legal history in the US, when the US court in the Miranda case said, no, it's not possible to be interrogated, arrested for a crime without having a lawyer in all steps of the proceedings. So the Miranda rights are not accepted in some legal orders. You can be interrogated, and you can come to a forced confession, and then according to this coerced confession, you can come to a deal, and all that can be based upon wrong evidence. So you have now to work more on what are these legal roots, the differences, and what has to be done in the legal orders. They do not have the same level of protection. Thank you.
Thank you, Athena, for your comments. I think that the presenters, the panelists, has 30 seconds each to reply. So please, I don't know if Dorota wants to start.
I think I can be even shorter. Thank you for a very interesting comment. I will obviously take into account all your remarks. Just to clarify, it's not that we don't have a letter of rights that every suspect who is arrested gets. They get the written information. They confirm they have it, but in practice, the right is not guaranteed because, for example, there is no mechanism of mandatory postponing the interrogation when the lawyer is on their way. So it's not that we are not exactly like the right is formally present at the legal system, but it is not in fact guaranteed, which also is connected with the issue of lack of implementation by Poland of the EU directive on the access to the Defense Counsel. Thank you.
Thank you. And I don't know if Patrick wants to reply very quickly.
Yes, I will try to reply to these very interesting questions. I will try, I will say that the thing that we can do is to try to find a balance. That's the most important thing, a balance with the economic matter, as you were referring to, and the environmental matter. This is in terms of your second question. In terms of your first question regarding the needs of the future generation, of course that we don't know which are their needs, all of them yet, because for example, when I came to study to Italy 2 years ago, I didn't know that I was going to spend a year and a half trapped in a room doing online lessons when I came to study in person. So what we need to do is to do our best to find the balance now in order to leave a better place for the future generation. And when we are thinking about the future generation and the measures that we're going to take also, we need to consider which future generation we are addressing to. It's like a future generation of 10 years, from 10 years from now, from 15 years from now, or from 17 years from now. But I would say that the key is to finding the balance with the environment and the economic matter in terms of your question. I'm sorry that I had to be this short.
Thank you so much, Patrick. So thank you to all of you. It has been a very intense and long session, so I'm really happy. I think that we have still some questions left open, and so I will write to the speakers the question that I cannot pose into this session. I invite you to do the same, so to keep the discussion going. In other channels, writing to one each other. And so I thank you for having applied to the YCC, and I hope that there will be many other occasions, hopefully in person, to see and to discuss on these very important topics. So thank you very much, and bye-bye, good night, good evening, and see you soon. Bye-bye.
Bye.
Next.